Good afternoon. My name is Shireen Soti. I am a Senior Associate in Jones Day's Global Disputes Practice, coming to you live today from Paris, France. It's my distinct pleasure on behalf of the Campaign for Greener Arbitrations, as well as Jones Day, to welcome you here today. We are very, very happy to have you here today for our second global launch session of the Green Protocols. We recently held our first session last Friday, and we look forward to presenting to you again today. The Campaign for Greener Arbitrations is an initiative to reduce the environmental impact of international arbitrations. It was founded by the international arbitrator Lucy Greenwood in 2019 with the aim of significantly reducing the carbon footprint of arbitration proceedings and within the arbitration community. In 2020, the Campaign for Greener Arbitrations established a steering committee comprised of members of the arbitration community, including practitioners, institutions, and legal service providers who each have a stake in the continued improvement of international arbitration. A fundamental objective of the steering committee was the establishment of a framework and a set of protocols to promote better environmental behavior through a series of action items. Through the efforts of a dedicated working group, we recently launched the public consultation phase of our draft framework and Green Protocols. Today, we have two objectives. One is to make you more familiar with our 6 Green Protocols, their accompanying framework, and our model Green Procedural Order. And the second is to solicit your feedback. As we are currently in our public consultation phase, we are seeking your input on the content of the draft. We have therefore designed this webinar to be as interactive as possible. We encourage you to actively participate in this session by giving your live feedback in our chat box. We are eager to hear your comments and impressions on the draft protocols and your thoughts on the various topics which are covered. To get you started, could you please go ahead and post a quick line in our chat letting us know from where you're signing in today. Please also feel free to submit anonymous feedback in a private chat to any of the presenters here today. You may also email feedback, which you have, to protocols@greenerarbitrations.com until mid-March 2021. If you have questions during the webinar that you would like to ask any of our speakers, please submit them in the separate Q&A box at the bottom of your screen, not in the chat box. We will have a brief Q&A at the end of the session. Please make sure to send your questions to all the presenters and not to anyone individually. And one last housekeeping note. On your screen, you will see our slides and/or the video of the speaker. Feel free to adjust the layout settings to side by side in order to see both at the same time and drag the divider to the left to have the view evenly split. The slides will be available to the participants after the event, and the event will be recorded. We are thrilled to have a very large number of attendees signed up for our 2 global sessions. The latest count, excuse me one second, I'm just having some technical difficulties here. I need to close this out. Okay, I think I'm all set now. Excuse me for that. We are thrilled to have our latest count revealing that we have over 468 attendees for the two events combined. And today we had over 330 registrants. So we are very happy for that large response, even if everyone can't be with us here today. But the overwhelming enthusiasm surrounding this event and the launch of the Green Protocols has made us quite optimistic about the potential for their success within the arbitration community. The registrants today hail from all parts of the world, as you can see in the graph before you and in our chat. We intend to make this public consultation phase as regionally diverse as possible by holding throughout the month of February a series of interactive regional events designed to engage key players in each region. Please be on the lookout for further communication in that respect. Today, we also have all types of actors involved from the field of arbitration. We have law firms, arbitrators, institutions, and even in-house counsel present with us today. As you will note later in our session, each of our Green Protocols is specifically designed to fit the needs of each of those actors, as you will learn a little bit later today. But we are really delighted to have around 60% of our attendees from law firms and chambers, over 13% of independent arbitrators with us today, as well as, it seems, members of institutions, in-house representatives, as well as other, which I believe encompasses as well students. So very happy to have all of you with us today. Our regional breakdown, you can also see on the left-hand side of the screen, is rather diverse as well, with many participants coming from Europe and Asia, but with also representation from Latin America, the Middle East, North Africa, Africa, as well as the US and Canada. So thank you all so very much for being with us today. Now I am very, very pleased to introduce my colleague, Linda Hess, a partner in our capital markets practice here at Jones Day. She is also based here in our Paris office. Linda advises clients in the area of capital markets, securities law, public M&A, and corporate governance under both U.S. and French law. Her practice includes advising on environmental social governance, ESG matters, including sustainable finance transactions, green frameworks, ESG disclosures, and risk assessments. Linda is an active member of Jones Day's ESG working group. Thank you for being with us here today, Linda.
Thanks, Shireen, and thanks so much for inviting me to speak. It's a pleasure to be with you all and to be here with as part of this working group. We at Jones Day recognize the importance of the principles which the campaign seeks to highlight, and I think it's really a true statement on forward-looking progress to see that people are taking essentially the bull by the horns to bring to forge consensus, propose really concrete framework so that not only our clients but our all of the people that are working in our legal industry and law firms, chambers, etc., can really come around the table and forge some consensus on how to make a difference with respect to climate change and with respect to ESG issues generally. Lucy Greenwood has done a great job, and the whole campaign that has put together these suggestions are great. I'm pleased to be among arbitrators, as Shireen pointed out, a transactional lawyer. So it's great to see that people are making progress, and this is something that we'll be taking a look at on our side, on the transactional side. As well. The Green Protocols are practical steps that can be easily implemented in whole or in part, and I think that flexibility is absolutely key to making sure that we get as much buy-in as possible, and I think these working sessions are a great opportunity to do that. So thank you very much for having me, and good luck for the work you'll be doing later on today and in the future.
Thank you, Linda. Now, I am very pleased to introduce the founder of the Campaign for Greener Arbitrations, Lucy Greenwood. Lucy Greenwood is an independent international arbitrator specializing in commercial and investment disputes. She has practiced international arbitration since 1998 and has acted as an arbitrator in more than 50 arbitrations since becoming a full-time arbitrator in 2017. She is highly regarded for her prompt, efficient resolution of disputes and active case management of arbitrations. She is a chartered arbitrator, a member of the State Bar of Texas, and a solicitor of the Supreme Court of England and Wales. Lucy Greenwood is listed on all major arbitration panels as well as on Global Arbitration Review's arbitrator research tool. She is a trustee of the Chartered Institute of Arbitrators, past chair, International Committee, Dispute Resolution Section of the American Bar Association, as well as the past chair, North America branch of the Chartered Institute of Arbitrators, and a fellow of the College of Commercial Arbitrators. In 2019, Lucy Greenwood launched what she termed her Green Pledge to minimize the impact of her arbitration practice on the environment. The Green Pledge caught the attention of the wider arbitration community, and soon hundreds of individuals had signed up to the pledge. Lucy realized that while the Green Pledge worked for those who practice as arbitrators, the arbitration community was keen to get behind a broader campaign to reduce waste and unnecessary travel that often occurred in international arbitration. As a result, she brought together representatives of key stakeholders in international arbitrations to spearhead the campaign for Greener Arbitrations. We are very excited to hear your insights today, Lucy. Thank you for being with us.
Thank you very much, Shireen, and good afternoon, everyone from the UK. It is so inspiring to see so many participants joining from all over the world in this My Afternoon. So thank you all. Thank you for taking this time out of your busy lives today to learn more about the Green Protocols. But before we get into the detail of the session, the real meat of the session, I just thought it might be helpful to give you a little bit of background to set the scene, if you will, to give you a sense of where the Green Pledge and then the campaign for Greener Arbitrations really came from. And many of you on this call will know, because I'm not shy about talking about it, is that I spent 10 very happy years living and working in Houston, Texas. And as Shireen says, I'm a proud member of the State Bar of Texas. One of the most traumatic experiences of my life was sitting the bar exam, but I got through it, and I'm very proud of it. And on a clear day in Houston, from my office in downtown, I could look right out, and if I really squinted, I could see the refineries on the Gulf Coast. When we went away for the weekend, driving back into town, you could see nodding donkeys, and I loved seeing them in particular. You know, I drove 30 miles to and from work every day in my Dodge Grand Caravan minivan, which I think did about 10 miles to the gallon. I filled up happily, enjoying the fact that gas was about $3 a gallon then. All my clients were energy companies, and all my work was hydrocarbon-based. And I saw my clients adapting, evolving, embracing environmental, social, and governance principles, and I didn't really take any notice of it. It was my job to advise them on their disputes, and really not a lot more than that. And although I consider myself fairly environmentally aware in my personal life, as I say, when it came to my professional obligations, really that was somebody else's problem. So there's a slightly trite saying which goes along the lines of all we have to do is wake up and change. And for me, I woke up back in 2018 now when I was chairing a major energy arbitration in Houston. And at the end of the 2-week hearing, I looked at the wall of printed binders behind me and realized that during that entire hearing, we had not opened a single one of those binders. And to my credit, I was chairing the case, as I say, and I had insisted on electronic bundles. But together with my co-arbitrators, we had decided that we would have a set of bundles for the hearing room in case the technology didn't work. And from then on, I really realized that approach was not good enough. It simply wasn't acceptable to be so conservative about the technology when all the technology we needed was available. It also wasn't acceptable that, frankly, that arbitration in 2018 looks very similar to my first arbitration, which I'd done back in 1998. So I looked into the available technology, and as I say, it was all there. I looked into it and thought, why are we running arbitrations in such an old-fashioned way? We weren't embracing paperless arbitrations, far from it. We weren't taking advantage of video conferencing, not even to deliberate remotely or anything like that, certainly not very much to hear witnesses. The technology was there, as I say, to help us run arbitrations more efficiently and, frankly, more cost-effectively. It was also there to help us run arbitrations in a more environmentally friendly way than we were doing. But as far as I could tell, we weren't really using it for any of those purposes. So it was at that point that I woke up and changed, and I committed that I would run my arbitrations in a more environmentally friendly manner, and I would try and encourage counsel appearing before me to do so as well. And from then on, as Shireen says, the Green Pledge was born, and then it evolved into this broader campaign, which has such an exceptional, committed and diverse group of people as its steering committee. I have been so inspired by all of them, and I'm deeply grateful to each and every one of the steering committee members. But there's going to be a fair bit of talking today, but I want to be very clear with you now. Today is not about talking. Today is about action. And we all know that as an arbitration community, we are really good at talking. I mean, we absolutely love it. Before we were all confined to our homes like we are now, we would think nothing of jumping on a plane, traveling thousands of miles to speak at conferences, to listen at conferences. Sometimes I would say, maybe it's just me, to pretend to listen at conferences, to network, to socialize, to enjoy the fact that we were sounding our views in an echo chamber, really, of people that largely looked like us and largely sounded like us and pretty much thought like us as well. Now, we knew we were fortunate. I actually don't think I have ever been in an environment where people were so passionate about and so obviously loved their jobs. But I think we all should accept that we were pretty insulated from the impact of our behavior. And I would say that we were pretty blind as well to its consequences. So today is about how we build on those steps that many of us have already taken to reduce our impact on the environment. So today is really about action. I don't want to see the Green Pledge being debated at length at conferences. I want to see it being lived. And the Green Protocols are there to help us do that. They are a start. Now, they're very much not the complete answer, nor are they in any way perfect, although, frankly, what the working group has accomplished in a relatively short space of time is nothing short of phenomenal. But the Green Protocols are simply a roadmap to help us change. They're nothing more than that. So as I say, signing the Green Pledge isn't enough. We would love you to sign it to show your support, but it's not enough. Talking about it isn't enough. I don't have the time to spend time arguing whether a high-value arbitration has a larger carbon footprint than a lower-value dispute. We just don't have the luxury of that time. You don't need me to tell you how wasteful the practice of international arbitration can be. I can hit you with data and statistics. I can talk about the tons of carbon that each arbitration emits. I can talk about the long-haul flights and mountains of bundles, as I say, the unnecessary travel to the unnecessary meetings. But I think deep down, as I say, we always knew how wasteful our practices were. We just all thought it was someone else's problem. But now there's no getting away from it. We are in a climate emergency. And we have to do two things to respond to that. We need to mitigate and we need to adapt. And I think we should all agree that it has been, certainly for me, it's been astonishing how we have all adapted to the pandemic and how we have pivoted pretty seamlessly, frankly, to remote hearings, to online events such as this one. So many people have come up to me and said they're complete converts now to electronic bundles. And even before the pandemic, I've had really proud moments. I've rarely had a prouder moment than when I chaired a hearing shortly before the pandemic hit, and all three arbitrators were there marking up their documents on screen. There's real converts to the idea of reducing travel, and this is absolutely key to our message. It is vital when you think that over 93% of the carbon emissions caused by an international arbitration relate to travel, particularly air travel and particularly business class travel. So the pandemic has really shown us how we can mitigate our practices and how we can change. The change to our way of working as a result of the pandemic has been the biggest change in international arbitration since I began practicing almost 25 years ago. But the real point about this is that we didn't endlessly debate it. We didn't agonize for months over which was the best online platform, how we were going to manage this virtual hearing. We just got on and did it because we had no alternative. And being very frank with you now, I don't think we have any alternative right now. We have to reduce our carbon footprint, and we have to change. And we can do this, we can change for many reasons. We can change to stay relevant, we can change to be more efficient, to please our clients, to deal with our guilt, to please our children, to appeal to new hires, to reduce our costs. There are many reasons for making the change, but the reason isn't important. Making the change is. And you've made a big change by joining the seminar today, and for that we are all very grateful. But you may well sit there and think that refusing to use hard copies or reducing the number of hard copies in your next arbitration won't make a difference. It will. Same with choosing to take one witness over video rather than in person. You may think that won't make a difference. It will. So in my mind, using the Green Protocols isn't really a choice. It's an obligation, and it's an obligation on all of us. And the working group have done this phenomenal job putting together the Green Protocols, which are a simple roadmap for all of us to follow when we want to reduce the carbon footprint of our practices. So thank you all for being there at the start of this journey, and I'm just really excited to see where it all takes us. Thank you very much.
Thank you so much, Lucy, for those inspiring remarks and for recounting the history of how we got here today. We are really grateful for you having initiated this process because it is so very important. So thank you so much for walking us through that. So now it is my great pleasure to introduce you to our distinguished panelists who make up the working group of the campaign dedicated to the formation of these Green Protocols, and who will be further acquainting you with them today. First, we have Christine Polciccio, the founder of Sopra Legal, a woman and attorney-owned company that specializes in the creation of hyperlinked submissions. She works with law firms and clients to transform traditional paper submissions into interactive digital presentations and e-bundles. Christine has published articles and consulted with U.S. federal and state courts, as well as other organizations, on best practices in the development of procedures for paperless filings. In addition to her work on the steering committee of the campaign, Christine is also a member of Arbitral Women, the International Law Section of the Florida Bar, and Seton Hall Law School's Women's Leadership Advisory Committee. Next, we have Sarah Bassani. Sarah specializes in international commercial arbitration and investor-state disputes. She heads Ada Shaw Goddard's investor-state dispute resolution practice, advising investors and host states alike. She is qualified in the U.S. and the UK and is recognized by a global leader by Who's Who Legal Arbitration 2021. Sarah represents clients before all major arbitral institutions and in arbitrations conducted under the Arbitral rules and foreign investment laws. She regularly advocates for her clients' interests before tribunals and advises clients on investment restructuring and strategies for minimizing the prospects of full-blown disputes. Sarah is an advocate counselor on managing and sharing the risks of arbitration through third-party funding, A2E insurance, CFAs, DBAs, and enforcing arbitral awards. Sarah regularly sits as a party-nominated sole and presiding arbitrator and is on CR Business Arbitration Scheme panel. She is passionate about mentoring, diversity, and sustainability in international arbitration and is part of the Protocols Working Group here today. Next, we have Maguelone de Bruguière, who is a senior associate at Herbert Smith Freehills Global Arbitration Practice in London. She is now based in London, but has also practiced in Paris as well as Tokyo. Magalon specializes in commercial arbitration with a particular focus on energy, commodities, infrastructure, and transport. She is currently on a secondment to Standard Chartered Bank's Disputes and Government Investigations legal in-house team. Magalon is passionate about diversity and sustainability in arbitration. In addition to being part of this working group, she is also the co-chair of the ERA Pledged Young Practitioners Subcommittee formed earlier this year. She is also on various internal Herbert Smith Freehill's diversity and sustainability working groups and regularly speaks and writes about this topic. Next, we have Olivier André, who is a client relationship advisor at Freshfields Brockhouse Derringer in New York. He advises on client relationships and leads the knowledge and business development initiatives for the International Arbitration Group at Freshfields in the Americas. Prior to Freshfields, he was the Senior Vice President of Global Development and International at the International Institute for Conflict Prevention and Resolution, or CPR, an ADR provider and think tank created by General Counsel at Fortune 100 companies, where he sought to promote efficiency and cost effectiveness in dispute resolution. At CPR, Olivier launched the CPR International Mediation Competition, the only international mediation competition to take place in South America, and led its first 4 editions. He also led YADR, a program to promote the next generation of international dispute resolution leaders, as well as CPR's cybersecurity programs and the Digital Transformation Committee, focused on the impact of new technologies on dispute prevention and resolution. As a founding member of the ICA New York City Bar CPR Working Group on Cybersecurity and International Arbitration, he contributed to the drafting of the Cybersecurity Protocol in International Arbitration, which was released in November 2019. He is a CPR and CEDR trained mediator and studied law in France, Germany, and in the United States. Olivier is a member of the New York and Massachusetts bars. Lastly, Rekha Rangachari is the Executive Director of the New York International Arbitration Center, NIAC. Founded in 2013, NIAC is a not-for-profit, non-governmental organization that promotes and enhances the conduct of international arbitration in New York. In her role at NIAC, Rekha collaborates with stakeholders and thought leaders in the space to advance scholarship and best practices. She offers educational programming, events, and trainings, and operates world-class hearing facilities in Midtown Manhattan. Rekha is actively engaged with the arbitral community at the state, city, national, and global levels. On the global level, Rekha is a board member of Arbitral Women and its Diversity Toolkit Training, Cooperation, and Events Committees. She is also a member of the Equal Representation Arbitration Pledge Young Professionals Subcommittee, and she maintains an active connection to academics as the associate editor of the Juris Investment Arbitration Conference volumes. She is also an adjunct professor at Seton Hall Law School and on the peer review board of the American Review of International Arbitration at Columbia Law School. I am very delighted to introduce all of these speakers who hail from different sectors of the arbitration world and represent a true diversity of interests and perspectives, which did indeed contribute to the work which we did together on the working group. I will not introduce myself. I'm not one for recalling my qualifications, but I just do want to mention one thing. I am on the board of Arbitral Women, and Arbitral Women is a media sponsor of this event today and has been very encouraging of the work done here by the Campaign for Greener Arbitrations, and a number of our panelists here today, including Lucy, are Arbitral Women members. So thank you very much to Arbitral Women for your support. And with that, I will turn it over to Christine for a further look at the Green Protocols and their accompanying framework. Thank you.
Thank you, Shireen. And welcome everyone again. We are thrilled to have you joining us today as we unveil the Green Protocols. So before doing so, we'll do a deeper dive into each protocol, but I would first like to share some background on our drafting process, give you a quick outline of the focus of each protocol, and then also touch a bit on an overview of the comments that we seek during this consultation period, which, as Shireen mentioned, will extend through mid-March. So the slide that you see now contains the guiding principles of the campaign. And Lucy touched on this as well in her welcome, but these guiding principles are what drives us and what we're asking you to sign on to when you sign the Green Pledge. Now, our working group was formed in early 2020 with the goal to develop some practical steps to accomplish these guiding principles. We sought to create a concise set of directives that would help to guide members of the community in this effort to reduce the environmental impact of arbitrations. Now, on the next slide we'll show, you can see that we started our work in 2020, as I mentioned, and this was just as most of the world was shutting down due to the pandemic. So it was really compelling to be working on this initiative while viewing images like the one you see here. Now, we share this today. I'm sure that you've seen either this or striking similar visuals that really illustrated what was perhaps one of the few highlights of our lockdowns, and that was the immediate reduction in pollution. We share this image today as a reminder that our actions have immediate consequences. Now, I certainly don't advocate that we remain isolated or stay in lockdown any longer than deemed necessary. But as we do emerge and enter what will hopefully be a more promising time in the coming months, this is perhaps the perfect time to consider what we're proposing here in the Green Protocols and really making an effort to make changes to our working environments now at this point, rather than simply returning to the status quo. So our campaign, as you'll see next, has focused on 3 critical areas that we feel will have the largest impact of reducing our carbon emissions. We've outlined those, and I think we can maybe flip, there we go, just so you can follow along too. The 3 areas are adopting clean forms of energy, reducing long-haul travel, which will be particularly tested as we begin to have travel options again in the near future, and then finally reducing waste. Particularly, we focus here on the reduction of paper, the hard copy filings that are used in arbitrations. So we will share some practical steps on how to address each of these areas throughout the protocols. Now, moving along to the structure of the protocols, we have developed a series of 6 separate protocols that are used in conjunction. They can be reviewed individually or in combination as appropriate to your role. We began first with the Arbitral Proceedings protocol, and we did consider some different approaches, but ultimately decided to address specific stakeholders through the various protocols. Now, in addition to the 6 protocols, we also offer a model procedural order, and you'll hear a bit more about that as well. Holding everything together is our framework file, the framework for the adoption of the Green Protocols. I should also note now, if you saw in the chat, we have the link to access all of these. So please do take a look at the protocols either now or after the session. If you have one takeaway from my portion of the presentation today, it would be to begin with the framework. This document is your roadmap to the 6 protocols, and it also provides some additional insights into the interconnect of these files. An interesting fact is that the framework actually came to be last. We were nearing the end of our drafting process, and we realized that we were lacking a type of unifying or central message. So that can all be found in the framework. So once again, I remind you to start with that as you look and do a deeper dive into the protocols. Now to just do a quick overview of each of the protocols. I think their titles will rather clearly indicate who the intended stakeholders are, and I remind you that some of you may find that multiple protocols are applicable to your practices. But to begin with an overview, we first have our protocol for arbitral proceedings. As the name implies, this is our series of measures that can be implemented in an arbitration. And accompanying this is our model procedural order. This document can be used in its entirety in an arbitration, but you can also take sections of it, and the tribunals are encouraged to implement those into their procedural orders. We next have a focus on law firms, chambers, and legal service providers. And here we look to extend beyond just arbitral proceedings, but look to the daily operations of these organizations. And I note that our goal is for this protocol to be adopted by entire organizations, but it most certainly can be implemented by individuals within these entities as well. So if that applies to you, please have a look at that one. Next, we turn to our Green Protocol for Arbitrators, and here, as its name suggests, we focus on the conduct of individual arbitrators throughout the course of a proceeding. And then we have our Institutions Protocol, which gives some action items for arbitral organizations. Now, rounding out the protocols list, we have our final two, where we extended beyond to the wider community, and we provide guidance in our Protocol for Arbitration Conferences to those who plan such events to encourage them to do so with an eye toward more greener practices. And then finally, our Protocol for Arbitration Hearing Venues. So here we are directing those hosting facilities with advice on minimizing their environmental impact. Now, throughout the protocols, you will see a series of unifying principles. These are our lists of sustainable measures. In each protocol, we have some variations on each of the items listed here, and it's been tweaked to fit the particular stakeholder that we're addressing. But in general, we're identifying some practical ways to adhere to these sustainable measures. Again, I note the importance of those areas of travel, clean energy, and waste reduction, but we also include guidance on other topics as well, such as social responsibility considerations. Now, as individuals and organizations begin to implement these measures, we also want to highlight some outlying considerations that you should keep in mind. Again, the materials on this slide are included in our framework file, so you can certainly go back and review in more detail later. But I highlight a few of particular importance, namely diversity considerations and costs and efficiency as well. So there's, again, that whole list that you should keep in mind as you start to implement the protocols into your practices. It's also worth noting at this point that the content of our framework file and our Green Protocols and your whole support of this initiative is in no way intended to deviate from any existing arbitration agreements or orders that are already in place or any applicable rules. We are sharing this guidance as part of the larger effort, as Lucy mentioned, of this voluntary agreement we are seeking among the arbitration community at large. Our goal here is to really begin to shift behaviors and encourage everyone to act with a continual thought toward the impact of our actions on the environment. Now, we know that we're lucky today to be joined by participants from around the world, and think of the collective effect that even small shifts of behaviors, particularly in those areas of travel, energy, and waste reduction, will really have. It'll be a tangible impact if we all practice this on a global level. So I encourage you today to take these protocols, and as we all return to our corners of the earth, start to implement the practices that we've suggested here. We're challenging you at this time to stretch beyond your comfort level and push for these changes that may seem a bit inconvenient or perhaps outside of the norm of what you've done in the past, but they will ultimately lead to a better future. Now, with that, we are turning to you, the community. During this consultation period, we are not necessarily seeking a complete rewrite of the work that we've done, but we are urging you to take a look and ask that you review our suggested measures. We want to hear your thoughts. Perhaps you'll identify some suggestions we've overlooked, or there may be some areas that require some clarification or some editing. So we're open to hearing your thoughts once you take a look. In particular, we're seeking comment on the tone of the protocols, whether the language should be mandatory or opt-in. We'll touch a bit more on this and the requests later in the presentation, but I do ask you to keep these thoughts in mind as we touch on each protocol. Now, before turning over to my fellow presenters today, I'd like to share a statistic that some of you may be familiar with if you have visited our website or if you've heard Lucy speak, but the campaign has conducted an initial study of a medium to large size arbitration, and it is projected that just under 20,000 trees could be required to offset the carbon emissions from just that one arbitration. So we see a figure, we see that number, but if you really let that sink in, it's quite astonishing and upsetting. Now is the time where we are working to reduce this number. So let's see what we can do in this collective effort to pare that down so that it's not as large of a number. With that, I will pause here and turn it over to the rest of our working group to walk you through a bit more of a deeper dive into each of the Green Protocols. I think we'll return to Shireen to introduce the Arbitral Proceedings Protocol. Thank you.
Thank you, Christine. So hello again, everyone. I will be now presenting to you the Green Protocol for Arbitral Proceedings. This draft protocol concerns the behaviors of parties and arbitrators and suggests tangible measures which can be implemented in specific arbitral proceedings. In Section 1, the manner in which parties and tribunals decide to adopt this Green Protocol is left open. They may either choose to adopt the entirety of the protocol or only component parts thereof. In addition, they may either adopt its content as mandatory provisions or simply as guidance. And once again, this is the framework in which we've constructed it, but of course your feedback is welcome on what as Christine just mentioned, is the appropriate language to adopt in that respect. So from the language that we've used currently in these drafts, for example, a tribunal could decide to officially adopt a Green Protocol, this particular Green Protocol in arbitral proceedings, through a procedural order. As you will hear from our next speaker, the model procedural Green Order has been drafted in order to accompany this particular Green Protocol for arbitral proceedings for that specific purpose. You will find interspersed in this draft protocol references to particular sections of the model Green Procedural Order where draft language can be found for inclusion in a tribunal's procedural order. In other instances, it may be the parties who decide to incorporate an obligation to adhere to the Green Protocol on arbitral proceedings prior even to the commencement of an arbitration, either directly in their arbitration agreements or in other agreements between the parties prior to the initiation of a dispute. Those could take the form, once again, as mandatory provisions or simply as something which should supplement the relevant arbitral rules. And other times, either tribunals or parties may simply wish to refer to the entirety or parts of the Green Protocol as non-mandatory guidance for the arbitral proceedings, something akin to the IBA guidelines or other soft law instruments which exist out there in the arbitration community. Aside from these notes on initial commitment, this Green Protocol addresses various phases of a typical arbitration proceeding and the types of behaviors that may be adopted by parties or tribunals during such proceedings in order to reduce their environmental impact. In Section 2 of the Green Protocol, the conduct of the proceedings is discussed. A default rule is established for electronic communications and correspondence, and the use of shared technology platforms and electronic annotation of documents is encouraged. Printing hard copies is discouraged, but where printing is necessary, actors are encouraged to minimize the environmental footprint of printing. For example, by using A5 paper, grayscale, double-sided settings, environmentally friendly toner and ink, and or reduced impact type of paper, such as either recycled or recyclable paper. The use of suppliers and service providers committed to reducing their environmental impacts is also encouraged. For example, those committed to using green energy or reducing their energy consumption or avoiding the use of plastic or single-use items. In sections 3 through 7 of this protocol, the various elements of a typical international arbitration proceeding are discussed: the written submissions and documentary evidence, document production, witness and expert preparation, hearings, and possible settlements. Electronic documents are once again favored over hard copies, but where a tribunal expresses preference for hard copies of written submissions, it shall endeavor to limit printing only to the specific documents which it considers essential for printing. This goes once again to Lucy's point, we want to avoid having a whole wall of binders behind the tribunal which don't even get cracked open during the proceeding, and the same goes for counsel. To the extent that we can only print perhaps those key documents which need to be marked up on paper as opposed to electronically, then we should endeavor to reduce that specific printing to only those necessary documents. The creation and sending of USB keys is also discouraged, as is the production of duplicate exhibits multiple times. So where documents are lengthy, the production of extracts is also encouraged, and document production shall, by default, be conducted electronically. The draft protocol expresses a preference for video conference consultation of witnesses and experts rather than in-person. Where travel is required, the number of in-person participants should be limited. The draft protocol further stipulates that pre-hearing conferences and procedural and substantive hearings should be conducted by preference virtually via either video conferencing or telephone. Where in-person hearings are required, actors should adopt a number of measures. They should endeavor to use environmentally friendly travel options and avoid unnecessary travel. They should limit the number of in-person participants, allowing other members of the team to participate via video conferencing. They should consider conducting cross-examination via video conferencing. They should engage service providers such as court reporters or interpreters located in the place of the hearing, and they should use technology to display documents along with utilizing electronic bundles. The draft protocol sets out similar standards for the conduct of settlement discussions between the parties. And the last two sections of the protocols, 8 and 9, reiterate that unnecessary travel should be avoided. Where travel is necessary, travel options that minimize carbon emissions should be favored, and the need to fly should be questioned. Given the disproportionately high carbon emissions generated from air travel, where flying is deemed unavoidable, at least offsetting flights should be considered. However, given that behavioral change is really the primary objective of these green protocols, offsetting should only be used to address residual emissions. There is a lot more to say about this particular protocol, but I would like to note very quickly that we intend on this working group and part of the wider steering committee that we will provide, in addition to the protocols themselves, guidance and particular facts and means of implementing these various suggestions. So even if you can't envision yourself right now adopting, marking up electronically your documents, well, we will be very happy to accompany you through that process and provide you with tangible steps in order to be able to accomplish each of these different steps in your practices, in your wider organization. So with that, I'll turn it over to my colleague Mag to present the Model Green Procedural Order. Thank you.
Thank you, Shireen. I won't spend too much time talking to you about the Model Green Procedural Order, purely because, as Shireen mentioned, the PO tracks the language in the Protocol for Arbitral Proceedings, save that obviously it's drafted in mandatory form. The procedural order is intended to act as a useful tool for those who are looking for readily crafted language and guidance to incorporate in their procedural orders. And the important thing to note is that it can be used both in new and in existing arbitrations. And that while we're currently in our consultation phase for these protocols, of course, we would encourage all of those of you who are attending this webinar to consider whether certain parts of the PO as it's currently drafted could be adopted in your ongoing proceedings. As Shireen mentioned, the various sections of the procedural order track the Protocol for Arbitral Proceedings, and there are cross-references to those various sections. And you can adopt the procedural order in full or in part. And it is very much drafted in opt-out form. So you and parties can adapt it to mirror the needs of their proceedings, taking into account some of the criteria which Christine mentioned at the outset. So, looking at the applicable laws to the proceedings, the size of the proceedings, the ability of the arbitrators and the parties to comply with some of the requirements that are in the procedural order, and the effect that it would have on confidentiality and whether the correct cybersecurity measures are in place to implement some of these recommendations. So naturally, we aren't suggesting that this is a one-size-fits-all procedural order. It is very much a tool to be adapted by the parties and by the arbitrators, also to take into account their own procedural timetable and process preferences. As Shireen mentioned, the procedural order will be amended in line with comments that we receive on the protocol on arbitral proceedings. I suppose one thing to flag in relation to the PO is that when it comes to travel, and in particular to the cost of offsetting travel, the procedural order does envisage that it would be included as cost to be allocated in any final award. And that's something we would welcome people's views on, as we know that it's not something that's commonly done in proceedings to date, but we would hope that it would become more common practice. I will now pass on to Sarah, who I believe will be talking to us about the protocol for law firms, chambers, and service providers.
Hello, everyone. Good morning, good afternoon, and good evening, depending on where you are in the world. Thank you so much for joining us for the second launch, global launch of the protocol and framework. I have the privilege and honor of cantering through the Green Protocol for legal advisors, which encompasses law firms, chambers, and legal services providers like technology providers or independent court reporters and transcription services. And having looked at the list of attendees, that means it's about 2/3 of you. So hopefully I've got your attention, and we can just quickly go through these protocols and how you can implement them in your organization to make an impact. The first point I'll mention is that the protocol sets out an initial commitment to work within your organization to implement the protocol that we've developed, or if you prefer, to develop your own policies and best practices that are based on the protocol. And because I know how busy all of you lawyers are, we've suggested that this be undertaken either in conjunction with the leadership team of your organization or through the appointment of a green ambassador who'd be responsible for implementing those commitments and practices within your firm. The idea here is just to ensure that there's accountability and therefore increase the likelihood that these suggestions will be implemented in practice. So having someone in charge and responsible is always a very good way to do that. The second and third protocols provide recommendations and actions to use clean or renewable energy sources where possible, and also to reduce energy consumption through the use of facilities and equipment. So I like to think of these as the set it and forget it items that can really make a huge impact on your organization. The fourth and fifth sections set out commitments to encourage the use of technology to reduce the use of paper, travel, and short face-to-face meetings. This includes, providing staff with training and developing their technological skills so that they'll be inclined to use that technology rather than paper, the trees, or meetings, as it may be. The sixth protocol deals with something that all lawyers will be exceedingly familiar with, and that is the mountains of paper that are often associated with our work. This, again, deals with commitments to encourage either minimizing printing or the use of paper generally, and where you do need to print, to use measures that will reduce the environmental footprint. The seventh and eighth sections encourage recycling and reducing the use of single-use items, such as, plastic water bottles, and generally eliminating plastic wherever we can. And at number 9, we set out recommendations to partner with organizations that adopt sustainable practices, like sustainable catering companies and printing services, and wherever possible to try to use local services providers. So if you need a transcription service or a interpreter, to try to attempt to use somebody who's local as opposed to flying in someone for that particular case. At number 10, again, something that we're all able to relate to and perhaps longing for at this stage, and this deals with recommendations to encourage lawyers to travel responsibly, including thinking twice about whether we need to travel at all for a particular event, or how large the team needs to be when you are traveling, as well as putting in place policies to ensure that staff can work from home. I think perhaps what has done more for this than anything else is COVID, because prior to the pandemic, I certainly had my doubts about how well hearings could be done virtually, but I think now that we've all been forced to use alternative measures, we can see that at least for the procedural hearings and hearings that are, on legal issues alone, that this is a very good alternative that actually works really well. And most parties are quite happy to save a huge amount of cost, so it really can be a win-win for your clients as well. At sections 11 and 12, we set out recommendations to incentivize sustainable behavior for the staff at your organization, like subsidizing the purchase of electronic equipment and encouraging staff to attend educational events about sustainability or to volunteer with organizations that have sustainability focus. And last but not least, Section 13 of the protocol covers commitments to consider offsetting residual emissions. Again, our first and foremost goal is to try to get you to implement practical steps that will reduce the environmental impact, but where that can't be done, offsetting is an option. So with that, hopefully I haven't spoken too quickly, but we do really just encourage everyone to take this to heart. There's a lot, if we each do this, there's a tremendous amount of impact that this can have if every firm is to implement these protocols. So please do your best to assign a green ambassador and to get it going. I'll turn it over to whoever. Yeah.
Thanks, Sarah. That would be me again. I'm going to talk to you now a little bit about the protocol for arbitrators. Now, the aim of this protocol is to provide individual arbitrators with practical guidance to minimize their environmental impact during the course of proceedings, of course, but also in their wider practice. Now, the one particularity about this protocol is that it should be considered supplemental to the protocol on arbitral proceedings, which arbitrators are encouraged to adopt as part of the proceedings they oversee. So there is some degree of duplication in terms of the measures in this protocol, of course, but the reason that particular obligation in this protocol is considered essential is because that is how arbitrators can be most effective in reducing the overall carbon footprint, both of their practice and proceedings, by encouraging others and using their influence to encourage others to reduce their environmental impacts as well. Now, this protocol is divided into a number of sections. There is obviously the initial commitment to reduce the environmental impact of their individual practice. There's then certain sections dealing with commitments and actions to be taken to reduce printing and minimizing material waste during the conduct of proceedings on an individual level. That covers some of the measures we've already discussed. So favoring electronic communications over paper communications, preferring electronic case files and electronic annotations, only printing what is strictly necessary, and in doing so, taking the measures to reduce the footprint of that printing. So, we heard Shireen mention this earlier, printing A5 grayscale, considering the source of your toner, and ensuring that whatever has been printed is disposed of in an environmentally friendly way. Obviously, always subject to whatever local regulatory requirements and specific confidentiality obligations apply to the matter. There is also then Section 3, which is dedicated to the commitments that individual arbitrators can take or can make during the course of the conduct of their proceedings. That includes, as I mentioned, bringing this protocol as well as the protocol on arbitral proceedings to the attention of co-arbitrators and encouraging their adoption in the first procedural order. It also includes encouraging the use of electronic filing and e-bundling and the use of shared technology platforms throughout proceedings for the exchange and organization of materials. We've also included in Section 4 certain commitments that arbitrators can make regarding the use of technology, including video conferencing of witnesses and experts, or in relation to tribunal deliberations, and the use of e-bundles in hearings. And then finally, we have two sections, sections 5 and section 6, which look more closely at measures that arbitrators can make or changes that they can make to improve the energy efficiency of their working environments and various recycling commitments to, again, minimize the impact of their individual practice, both during the conduct of proceedings as well as during their other work commitments. And then finally, as we have with all of the protocols, we have commitments regarding the offsetting of residual emissions, including during travel. But as I will again echo what Shireen and Sarah have said, that we do not consider that offsetting is should be the first port of call as a solution. It is very much intended to be a measure of last resort for those residual emissions that are left once all other measures have been adopted. In terms of specific feedback that we're seeking for this protocol, now, as Lucy mentioned, when we started our drafting work at the start of this pandemic, we considered some of these measures would be relatively groundbreaking, or it would be difficult to encourage a sort of a change of behavior. But in many ways, the silver lining of COVID has been that the proposals included in these protocols are no longer groundbreaking at all. In fact, we've adopted them as part of our daily practice. So hopefully, none of these measures will fill anyone with any dread. We welcome comments on whether now we could go even further than what we've suggested in this protocol. What we would like your input on, especially from arbitrators, is whether we can go further in terms of making it a requirement for arbitrators to adopt the Model Green Procedural Order or the Protocol on Arbitral Proceedings. Currently, the language is relatively soft. The reason for that is because of some feedback that we had from arbitrators that they perhaps didn't necessarily always feel they had sufficient power to require their co-arbitrators and parties to adopt specific green measures. So we would welcome views on that. And we'd also welcome views, of course, on the feasibility of the measures that are recommended herein regarding the reduction of printed materials, the use of shared electronic platforms, and of course, the increased use of telephone conferences and video conferences as an alternative to travel throughout the conduct of proceedings. I will now pass on to Rekha, who I believe will be speaking about the arbitration conferences, or Olivier, sorry, for Arbitral Institutions Protocol.
Thank you. Thank you very much. Good afternoon, everyone from New York. It is a pleasure to be here in such good company. Before I get started, let me say that Freshfields is excited to be part of this campaign. The firm has been carbon neutral since 2007, and we recently signed the Green Pledge, which aligns perfectly with the firm's sustainability goals. Before joining Freshfields, I worked at an institution in New York, and I know firsthand that institutions often pave the way for great innovations in the arbitration communities. I am thinking, for example, of the work that has been done, the role that has been played, and that they continue to play in bringing more diversity to our field. I think we can all agree that during the pandemic, institutions have demonstrated their ability to quickly react, to change, and to adapt by switching almost overnight to online operations and video conferencing. So the point I'm trying to make here is that institutions are really going to be key to make the Green campaign successful, and that we really count on them to do their part to reduce the number of trees needed to offset an arbitration. I will say that for them, for institutions, it's not only an opportunity to continue to demonstrate their ability to innovate, but also to become more efficient and therefore provide a better and more cost-effective service to end users of arbitration. So a win-win. Everybody should think about this as a win-win for everyone, including, of course, our planet. Like the other protocols, the protocol for institutions encourages them to review their existing environmental policies and practices and see where changes, again, big or small, can be made to reduce energy, travel, and waste. I'll just focus on some of the measures that can be taken by institutions to encourage the use of technology very briefly for the conduct of proceedings. I only have 5 minutes, so I'm trying not to rush through what I'm saying. Many of the other measures that are in the protocol for institutions also apply to all protocols and have already been covered by other steering committee members. So in terms of technology, excuse me, we have seen institutions stepping in during COVID and encouraging its use to conduct remote hearings. That was really great. The protocol goes a little bit further, though, in suggesting that institutions going forward, and even in the post-pandemic world, should expressly encourage the use of video hearings in their rules, guidance, draft procedural orders, etc. If the rules are ambiguous about remote hearings, the protocol suggests that they be clarified to ensure that video hearings are always an option and that tribunals have the authority to decide that witnesses and experts be examined by video. Other recommendations are about minimizing printing and the use of paper, for example, making sure the rules allow for service of documents by electronic means, inviting the parties to communicate by electronic means only, not requiring hard copies of documents, encouraging electronic filings rather than paper filings. That is already the case with many institutions, encouraging the use of electronic bundles, electronic presentation of evidence, etc. So that's all I'm going to say because I only have 5 minutes, as I said, but I will end with 2 requests after this very brief overview. First, send us your feedback on the protocol for institutions. And for that particular protocol, I guess it would be interesting for us to know, for example, which of the suggested measures affecting the proceedings should be made mandatory for the institution's rules, or if these measures should just be mere recommendations. We'd be curious to know, what else you think institutions could do to be greener and at the same time, of course, more efficient and cost-effective. Should they make, for example, remote hearings via video conference a default in the rules? Should paper filings be eliminated altogether? Should green practices of arbitrators be considered during the selection process? So some of the things that we'd be curious to hear your thoughts about. We've heard at the beginning of this program that 20,000 trees would be required to offset the carbon emissions of an arbitration. That is the entire tree population, by the way, of Central Park in New York. So my second request to you and final request is please join the campaign, do your part, and start by signing the Green Pledge if you have not yet done so. Thank you very much. And I think it goes now to Rika, right?
Yes. Hello, everyone across jurisdictions. It is a pleasure to be here. Thank you to the Jones Day team, to Shireen, to Linda and Benoit, to Lucy and to Christine, as well as all the colleagues that have helped on the protocols drafting team. As you well know, it takes a diligent army to roll out initiatives like this one. I will close us out on conferences and venues. As the executive director of the New York International Arbitration Center, I have seen lots of traffic in our space as to conferences and venues. There is much carry through from one protocol to another, and this is intentional. For example, repeat focus topics include printing, energy consumption, and technology. Each list necessarily includes more items than may be operative to one conference or one venue. This notion of a thoughtful process in the nascent planning stages of conferences or as venues take in booking. So we ask you to consider during these global sessions as well as our regional roundtables, how do we build a fluid set of protocols that are flexible to stay current as our practice evolves? How do we message this for maximum consumption across the globe? Within the conferences and the venues protocol, you'll see common themes. How do we reduce energy consumption, waste, and carbon footprint? How do we focus on electronic and video communication and thereby avoid unnecessary travel? Specifically as to the conferences protocol, it speaks to planning in remote, in advance of the actual conference, conducting some events using a virtual platform rather than in person or even where multiple events are being held. And this hybrid approach in truth allows us to embrace delegates across jurisdictions as we're doing here today. Aptly, many of the arbitral weeks that happened in 2020 took advantage of being in remote, going online, and embracing a larger swath of our global community. Utilizing these electronic conference materials, accessing virtual platforms, accessing virtual check-in, and being really conscious of single-use items when we are again able to visit in person, right? The totality of the waste, taking accurate head counts of things like food, using local, staying local, traveling responsibly, and considering, although it is a last resort, how can we offset? Can we incorporate, for example, a service activity as a community during our conferences, and perhaps it even allows an opportune moment to step outside the conference hall and get some much needed sunlight. I add here that we may be mapping and discussing carbon footprinting at different levels across jurisdictions. I share with you that one colleague from our Green Pledge Steering Committee asked me in August of 2020 to share an anonymized data of carbon emissions from conferences. And I thought, I don't think we have that. I circulated this query to a small cohort of arbitral institutional leaders in the US, and I asked them if they had this info readily available. And they said they did not either. And we together realized, for example, Europe may be ahead of us in this regard, but we will catch up. Now more thoughtful, armed with these protocols as we begin conversations. One conversation can activate a cycle of change. If we can move to the next slide, please. Here we're talking about venues. So these protocols speak to daily operations, and as we make plans for hearings, venues are often allied with arbitral institutions, so conversations are happening in collaboration. The protocols place focus on venues and the parties who can request implementation of the protocols. We concretize key considerations here. How do we limit attendance to those only necessary? How do we limit waste and keep that top of mind? How do we, for example, keep hold of items like stationery and business development materials, only putting them out when necessary? It readily makes me think of, for example, in the NIAC space, we always had the candy jar out, and because it was out, I consumed lots of candy. Now, I didn't always ask myself, do I need to be eating this candy, or do I need that stationery that happens to be out? And so it's a consciousness level that we're asking you to think about, to stock recycled and recyclable papers in printers, and consider staff offsetting, again, a service activity, but that's really last resort. And then it's this idea, of how can we implement, how can we collaborate in advance of parties arriving at a venue. Leading a venue in New York, I'm delighted to report that we are now building out new space and taking consideration of these protocols. And we're starting with simple considerations and questions. How do we increase natural light and implement LED lights? Where can we use smart power strips and encourage clients to power down? At NIAC, I'll also share that clients often book with a 10-month lead time, and this allows us to have a collaborative discussion, to socialize the green protocols, to create compliance, and to bring all parties into the conversation of how we achieve the green movement. And so for both conferences and venue protocols, what we're asking you to look at is, can we go further, as Mag suggested? I'll conclude by echoing the importance of these global sessions and the subsequent regional sessions to follow, to socialize the protocols, to invite your comments, and to bring the Thinking Green movement top of mind. Thanks so much. I'll hand the mic to Shireen to close us out.
Thank you so much, Rekha, and to all of our presenters here today. So as you are becoming more familiar with these different protocols, what each of the protocols propose, I'd like you to please consider whether you may have already begun to implement some of the options which are contained in each of the Green Protocols. And feel free to type your answer yes or no in the chat box if you'd like. Have you, for instance, already attended a virtual hearing in your career at some point, or particularly during the pandemic? Have you switched your home or your office workspace to a green energy provider? Have you attended a virtual arbitration conference or webinar? Well, if you're here today, you can already check that box. Have you ever participated in a case where all of the submissions were provided only in electronic form? Have you offset your flights in the context of an arbitration before? And have you decided to hire a local court reporter or translator interpreter for an arbitration rather than having one come in from another jurisdiction? There are, of course, many other questions to consider and actions to take. We look forward to receiving your further feedback on the framework and the Green Protocols in the public consultation period, which will run until mid-March. Now we will open it up to questions from the audience. If you have not done so already, please submit any questions you may have in the Q&A box on the bottom right side of your screen. We will attempt to answer as many questions as possible in the limited time left today. We have a few questions in the chat and in the Q&A box, so I will just read them off, and if our co-presenters could take them as most appropriate, I will try to mention someone who could best address each question. So perhaps we can start with a question from, excuse me one second, let me get situated here. So we have a question here from, excuse me, Juliana Ianasu. I think I'm pronouncing that correctly, I hope so. It's a question to Olivier. And she mentions a lot of innovations can indeed be achieved by institutions. Do you think that in terms of strategy, the organization of virtual conferences, working group meetings after the pandemic is over should be required or encouraged? Olivier, would you like to take that one?
Sure. Well, I think it should definitely be encouraged. And I think that this point, if I'm not mistaken, is made in the protocols for conferences. But I suppose it might be also helpful to cross-reference this in the protocol for institutions, considering the number of conferences and committee meetings that institutions are organizing on a regular basis. I think from a business development perspective, it will be also something very interesting for institutions, because what the pandemic has shown, with the use of with those meetings and conferences taking place remotely, is that institutions can have a much further reach. They can, people can attend events from all around the world. They don't have to travel, so it's easier for people, at the other side of the planet to attend meetings. And so I think there is also a business development interest from institutions to continue to do this, basically.
Thank you, Olivier. We have another question from Dana McGrath. Have you considered encouraging law firms to supply lawyers electronic writing pads to avoid the use of paper notepads? I'm wondering if Sarah could answer that question.
Sure, I think that's a great suggestion. I actually have a colleague who uses that, and it's fantastic. It comes up, you don't lose it because it's electronic and you can send it to yourself, but it's a great program. That is considered in part, and where we say use technology, that is an alternative, but it might be useful to list out some of those additional technologies. Because I know when I initially think technology, I think Zoom as opposed to other technologies, but I agree with you, that program is fantastic. And perhaps what would be good is if we listed some more additional tools that are quite helpful and useful and are user-friendly, because that is one of them that is absolutely fantastic.
Thanks, Sarah. We have another question from Timothy Smith. How strongly should arbitrators push for a virtual hearing if one or more of the parties objects? Maybe Meg, you can take this one.
Yeah, thanks, Shireen. I think it's that actually is a very, very good question, and it's one which the drafting committee spent a lot of time considering when we were drafting the protocols. And in a sense, while that is one of the reasons why some of the language is not mandatory, because we do want to leave it to the discretion of arbitrators and of parties to make some of these decisions regarding how appropriate some of these measures are for individual proceedings. I certainly think that going forward there is more space now for arbitrators to more strongly advocate for virtual hearings where they're appropriate, especially if they're not disadvantaging a party. So in short, I can't give you a clear answer to your question about how strongly they should push, but certainly more strongly than they currently are doing. But obviously, it will very much depend on the case and the parties.
Thanks, Meg. We have another question from Jane Hughes. Some of your recommendations are very detailed. Plants in rooms and abolishing tea bags caught my eye. Do you think that the detailed nature of these requirements makes people more or less likely to adopt the protocols? Maybe Christine, you could take this one on.
Thanks. So that is a good point, and similar questions were raised throughout these past few months amongst our working group. And I think we sort of vacillated between paring it down a bit and just streamlining the list, but our intent in including some additional details, such as the ones you outline there, and I think in some of the protocols you'll even see a chart that's included with suggestions of some supplements that you can do. But again, our intent was more so to make sure that we are being as inclusive as possible. You know, you can take these lists and implement as much as you want of the suggestions. And so by being more inclusive in the list, we hope to bring to mind things that you may not have necessarily thought of. Reka mentioned the candy jar that's always out. But it's just things like this. We really did sort of review our working environments and think of all the things that we encounter on a daily basis and try to include as much as possible to help you trigger those same thoughts of, do I really need this? Is it necessary? Is there a better alternative that we can use? So yes, I think we opted on the side of being overly inclusive, but again, this is in no way a completely mandatory list, but we encourage you to adopt as much of it as you'd like and maybe push yourself to then add on a few more of those items too.
So I'm mindful of the time. We have just about 5 minutes left, and we do want to close out with a couple of last comments, but I'd just like to address one last question, and I'm sorry we can't get to all of the questions here today, but feel free to email us or to submit further questions in the chat, and we'll attempt to have the speakers get back to you quickly. One last question from Vanessa Naish, I believe it's pronounced. Interested to hear how users of arbitration, i.e. our clients, have received the protocol so far. Are responses generally positive, for example, aligning with the client's sustainability targets? We haven't yet gotten a very large response. We have gotten a lot of enthusiasm around the protocols, but in terms of substantive comments, we haven't yet. But perhaps, Lucy, I'm not sure if you want to make a couple of remarks on your general impression of how the protocols are being received.
Sure, yes, thank you, Shireen, and it's a great question. I mean, the short answer is the feedback from at the client, the corporate level has been overwhelmingly positive. At the moment, we have corporate representatives on the steering committee. It was very important to me when I set up the initial steering committee to make sure that I had representatives of every actor in the process, as we've described. So we go right from in-house corporate lawyers right through to legal journalists, legal tech people, and then all the usual players in an arbitration as well. What we're finding very much is that we're hearing from corporates that it's chiming very well with their ESG principles, the environmental, social, and governance principles, that we're seeing much more front and center of clients' obligations and expectations of their suppliers, law firms, and going right down to conference venues and hearing rooms and institutions as well. So as Shireen says, it's an early stage in the process. As you know, we haven't had the detailed feedback from that part or that segment of arbitration practitioners, but the initial response to the concept of the campaign has been extremely positive.
Thanks so much, Lucy.
If I may add, I just wanted to add 2 comments on this. One is that during the consultation period, the steering committee is really striving to engage with corporate counsel, basically to get their views on all of this, because we are very much aware that a lot of changes are driven by the clients of arbitration. So definitely we need to involve them in the consultation period, and so there's a second round of consultation period that is going to be taking place on the regional level, and that will be really, I think, focused on making sure that all the stakeholders of arbitration are there. I think the second point, from what I've heard, is the end users of arbitrations are very interested in this initiative because, as Lucy pointed out, it matches their ESG policies. They want to, we all want to do something good for the planet, but it also matches their goals for efficiency and cost effectiveness of arbitration. So there is a real synergy there with the end users of arbitration, I believe.
Yes, excellent point, Olivier. Thank you for raising that. Well, with that, I will turn it over to Christine to close out our session. But I would like to thank you all on behalf of both the campaign and Jones Day for your participation today. And please keep your eyes and ears peeled for future information on the further development of our protocols and tangible guidance on how you might implement them. So I'll let Christine give you some last comments, and thank you so much for your presence today.
Thanks, Shireen. And some of these comments have already been shared in the chat, but just to reiterate, we do encourage everyone to register for the Green Pledge and make sure that you follow us on social media so that you do stay in the loop on all of the updates here with the protocols. But now, today was the final of our 2 global sessions, and as others have mentioned, we will be hosting some regional events in the coming weeks. So be on the lookout for those, and please contact us if you are interested in participating and joining those events. I also remind you that you are now welcome to contact us at our email address that we posted, and you can also reach out to any of the working group members individually if you want to share some thoughts on your feedback or your comments, anything that you didn't have time to get to today, or things that you may think of as you review the protocols. So that's about it from here. We do thank you so much for your time today. And again, we're encouraging you, even though we're in this consultation period, there's nothing stopping you from going ahead and implementing the changes we're suggesting here. So please start with that, and thank you again for your time today.